welcome to Legally Speaking with me, Tarun Nangia. Welcome back to yet another episode of Saturdays with Singhvi, and it is a pleasure to have Dr. Abhishek Manu Singhvi with us on the show. As you all know, Dr. Singhvi is an eminent jurist. He's a 3-time sitting member of parliament, senior advocate, but he's added 2 more achievements, positions to his CV recently. May I also share with you that he is now chairman of the Parliamentary Standing Committee on Home and also appointed now to the Congress Working Committee, which is the apex decision-making body of the party. So indeed, 2 big, I think, additions to your curriculum vitae, both in the parliament, in the Ministry of Home Affairs, that committee, and also in the party. Many, many congratulations.
That's very kind of you for such a generous introduction, Tarun. But I'm the same person and the same interaction with you, I hope, as always, on the channel.
And today, let me introduce you the topic that we're going to discuss with Dr. Singhvi. It is the judgment on the Prevention of Money Laundering Act, which has been delivered by Justice A.M. Khanwilkar, Justice Dinesh Maheshwari, Justice C.T. Ravikumar of the Supreme Court of India. Of course, we all know this was in response to a batch of petitions to the Supreme Court of India, which were, in a sense, challenging various provisions of the PMLA Act, including twin conditions for bail, all of which we have earlier discussed also with Dr. Singhvi, is one of the much popular earlier episodes. And without holding you any space between you and Dr. Singhvi, let me ask him at the outset. So what are your first reaction and broad views about this judgment? What are the first few things that you would like to say?
I think, unfortunately, the first adjective which would come to mind would be disappointing, perhaps even deeply disappointing. It's not because, of course, you must discount in a lighter vein, you must discount everything I say with a bucket full of salt, because I was one of the main counsel who argued more than 4 or 5 of the major substantive points. But it is not really a loser's grouse. We've spent a lifetime in law, and we have, the wins and the losses, and you enjoy all of it. But it is disappointing because I think the larger arc of freedom of the individual should have been the backdrop in which these interpretative exercises, the asking by people like us of safeguards, the reading down of seemingly very, very draconian provisions, and the contextual ambience in which every citizen of this country knows, irrespective of political affiliation, knows the contextual ambience in which ED is functioning. These all are the backdrops which I think, unfortunately, the judgment is not given sufficient weight to. Ultimately, judgments have to be given in the context of operational realities. You can have a sterile law. A law will not say everything, do everything, cannot possibly cover everything. You as a draftsman cannot anticipate everything. But then you have seen in the light of experience over the last 8 odd years that the same law, which might have one kind of a passive, almost somnolent application in the hands of Tarun Nangia, has become a weaponization against individual liberty in the hands of Abhishek Singhvi. Now, judges cannot be divorced from that context, is all that I'm saying. It is not that this is not politics. This is not taking sides in any way. It is understanding the realities and the nitty-gritty of the operational context, and then approaching it in a way that the judges know how to plug the gaps, how to deal with the interstices to increase those safeguards, which will stop that kind of a thing. There, I think there has been a very great disappointment as far as I'm concerned.
You said disappointment. So let me ask you, if you could cite, say, at least 1 or 2 major disappointments, according to you, that you found out when you read the judgment.
There are many, Tarun. Let me start by, as I said, I argued more than 4 or 5 substantive points, but let me give you just 2 or 3 quick examples, and then maybe we can add more. And I'm now starting deliberately with the milder ones. The milder ones meaning where, and that is again another cause of very deep disappointment, you as a judge could have simply read down without striking down anything. So if I challenge a provision, as you know, and I'm making it simple for your viewers, you can strike it down as unconstitutional. But in many times, in many cases, you need not strike it down. You can just save it, uphold it by reading some elementary safeguards. Now, one of the points in that context, that's why I said I'll start with the milder ones, is search and seizure. Provisions like 17, 18, 19, etc. I won't go into the legalese of it. Those provisions, we pointed out some startling omissions or gaps which you as a judge, as a bench, could fulfill, could plug, could just read into. For example, you register a FIR today. In the afternoon, you register an ECIR, which is internal, by the way. Now, the judgment is required to give a copy. And immediately, you can start search and seizure under PMLA. Now, they have accepted that the predicate offense is the parent in the sense that if you quash the predicate offense meaning the principal offense, the main offense. So murder and proceeds of crime from murder. So murder is an IPC offense. If you have that crime with an FIR registered simply, no investigation, no charge sheet, no action on the main IPC. But the PMLA can start the proceeds of crime investigation on the same day by search and seizure, which is the most intrusive form of invading your privacy. Now, 3 days later or 7 days later, that FIR is withdrawn, quashed, removed because it is found that Tarun Nangia was in New York and he could not have murdered me because he was millions of miles away. Well, you have already searched me, seized me, you've already intruded on me, you've already punished me in many ways. So this is one aspect that you are a derivative offense, but you treat yourself as the principal, prosecution. The second one is you need, in most enactments, a judge or a judge element, a judicial element to give you warrants for search and seizure. Nothing is required here. You are just an officer, and now to boot, this judgment is held that you're not a police officer. So you simply make an opinion and you come into the house anywhere, you go anybody's place. Look at the powers you have. No judicial element is interposed that you have to go and seek some permission, some warrant, or show some cause to a judge that, look, I want to come into the house of Tarun Nangia because I have this material. A second related point is, for example, attachment. Now, you do have a power of emergency attachment, but it should have been riddled with safeguards. Today, emergency attachment means that nothing has happened in any main offense. There is nothing happened here. You first attach. And thereafter, you start investigation, you start inquiry. So it's putting the cart before the horse. See, it's not very easy as we just talk on academic programs like television. Imagine your property is attached. And 3 days later, your entire property is attached. Attached means frozen. You cannot deal with it. You may be in the middle of a sale. You may be in the middle of a whatever. Now, it is thereafter that I start inquiring and investigating. And after some time, either the predicate offense falls or even my own inquiry finds that no. First of all, there is no offense, or if there is an offense, it's worth 10 rupees, whereas I have attached Tarun Nangia for 10,000 rupees.
So attachment.
All this again, there is no system, there is no safeguard, and only the judges can put such safeguards. Take a more striking example. You have a property 20 years old, and you allegedly commit the predicate offense of murder today. How is it possible that that property is your proceed of crime?
It's not.
It's not physically possible. It's not mentally possible. It is not conceptually possible. It is not at all possible because you can't have a retrospective clock ticking. Well, and on what basis do they attach your proceeds of crime of that property? Just because this is the only property they can lay their hands on.
So
there has some causal.
Are you saying, and sorry to interrupt, that the bench should have put these kind of...
This is what the judicial element is for. You see, the executive may have erred. The legislature is broad-based, doesn't go into nitty-gritty. That is where the judiciary comes in. It reads into the interstices.
In fact, you know why? Before going into...
Let me say one more sentence. You see, therefore, what you have done, without quite saying so, is turning on its head the triple test. Entire concept of money laundering is, one, there must be a main offense.
Okay.
What technically is called predicate. Second is, from that must flow proceeds of crime.
Proceeds of crime.
And third is, there should be an attempt to launder it. nimbly to project bad as good, to convert black into white.
Can you give an example?
Now, how is it possible that the murder is committed in 2021, but the property is owned by Tarun Nangia from 2000? How can that murder have proceeds of crime relating back to the property? This is the example I just gave. Then there are many more things, but one more very, very dangerous conclusion, I'm using that word in this judgment, which will be misused, is that you are treating this as a standalone offense. Standalone means this triple thing I gave you. You are not really applying it strictly, because be it when the crime is committed, be it when the proceeds of crime, you are not showing the causal nexus.
Yes.
And then ultimately the worst part is you are not treating, tell me one thing, suppose you have only murder and you have only proceeds of crime. And suppose you put the proceeds of crime under your bed and do nothing with it. This is the way law is tested. I admit that you have committed murder. I also admit that from murder you have put proceeds of crime under your bed. Now you can be convicted of murder, no problem, that's not the issue. You can be convicted of theft, no problem, that's not the issue, the IPC offense. How is it that you are charged with money laundering?
It's not money laundering because laundering.
You have done no effort. But that is why the third test is given in the Act. But today, you have obliterated that. You have really said that mere possession, mere concealment, mere having something which is alleged to be proceed of crime is money laundering. For example, you evade income tax and keep some money under your bed. Nobody is saying you can't be actioned under the Income Tax Act.
Yes.
These are all different concepts. Now you have obliterated the distinction between money laundering and several other things, including income tax. So simple possession and concealment, remember the effect of this, it's very wide-ranging, has been virtually held, in fact held, to be money laundering.
So basically, if tainted money is not even projected as untainted, there is no attempt made to launder it, even then you can be charged with money laundering. Is that the effect?
Exactly. It is the direct, not the effect, it is the direct holding in this judgment.
Right.
And they have said that the money laundering starts virtually from the proceed of crime, but you don't follow it up to the end, that it is laundered.
I want to ask you one more thing before going on to the other 2-3 points that you said you will make. In the initial pages of this judgment, what is said, it's very interesting. It said that the Nikesh Tarachand Shah judgment was delivered by Justice Rohinton Nariman, which in a sense held section 45 of the PMLA as unconstitutional. Now the Parliament amended section 45 to remove the defect noted in Justice Nariman's decision. This is what the judgment says, that Justice Nariman's decision had a defect which the Parliament removed. And because of that, after the Parliament amendment, the twin condition of bail was again revived. And the judgment says that that was the reason that after the Parliament again amended, that bails were denied to many people, citing that again the Parliament has amended section 45. Could you just clear this for all of us? Because this is like one of the interesting points that we found in the judgment.
This is a major substantive point. That's why I started with the easier, softer points of interpretation and safeguards. This is a substantive point. And this is possibly the most disappointing, and I could even use the word shocking. Let's just step back from your amendment. Just step back for 30 seconds. Before the amendment, the section as it stood virtually said that you have to prove that you're not guilty before you can be entitled to bail. The argument before the Nariman bench was that at the stage of the interim, with no documents, in fact, not even the ECIR, it is impossible for any accused to show that they are innocent. Indeed, it is impossible to show even that they are significantly likely to be innocent, because the man has got nothing, no papers, no ECIR, nothing. So it's not a reversal of burden of proof, it's a reversal of the very concept of innocence. On that and other reasons, Justice Nariman, who, as you know, is one of the most outstanding jurists of our country, not merely a retired judge, not merely a judge, a great, thinker, wrote a comprehensive judgment. Now you pick up the amendment, I don't have it in my hand, and read out. What is the word which has changed this lacuna? Nothing. The amendment has says nothing of the sort. Revival means what? You had to put something which could take away the lacuna. Now, how can you take away the lacuna when it is unconstitutional itself to presume that you are guilty instead of innocent? Justice Nariman held it on a point of constitutionality.
Yes.
So an amendment could not easily have cured it. You see, so long as the burden remains upon you and you are presumed to be guilty, there is hardly anything you can do. But secondly, and more importantly, the amendment is before you now. There is nothing in the amendment which cures it, nothing. In fact, the commonly we held view was that it dealt with the other parts of 45, not this part at all. So that is a very sad part of the judgment, that it has taken away such a significant safeguard. And today, let me tell you what is happening. Today, there are hundreds of cases, the progeny of this, hundreds of cases across India. What does the man do? Forget the political cases. They are the high-profile ones. You hear about them, you read about them. Take the ordinary cases. I'm not saying that he's not guilty, convict him. I'm not even saying that you don't interrogate him in custody. I'm not even saying that give him bail next day. But you cannot get bail at all. Unless, of course, in practice, you do get bail. When everybody thinks they were sick and tired of having him, 3 months is too much. Even the ED says, no, please get out. But that's the way to look at liberty. You tell me, how will you get bail if this judgment is read in the way 45 it is interpreted? It is not possible. So that you take your good time, 3 to 6 months, which is, maybe if you're innocent, which is very likely the conviction rate being 0.5%. That means 95.5 people out of 100 are proved innocent. That guy spent how much time in jail, Tarun?
Yeah, significant. So I want to ask you that if a businessman is charged under the PMLA laws and, if he is prosecuted, the ECIR, which is the Enforcement Case Information Report, he has no right to see what he's been charged under. So how does he defend himself after this judgment? Because if he doesn't know what he's charged with, how will his lawyer even defend him?
This is very, very, distressing that something like this the court could have easily agreed to without any earth-shattering consequences. That is why I am critical of the judgment also. Now you are giving the softer answers. These are not things which will have earth-shattering consequences. Tell me one thing, if your file, ECR A is considered to exist on your file, it's considered by ED. ECR has to be there by way of an internal document, recording that, look, I believe this, etc. Then tell me, at the worst, something very important, national security or something very, very significant, barring that redaction, why could the court not say that must be given? And ultimately, it's linked to a predicate offense. The FIR is merely given.
So I want
much more draconian thing is not given, whereas the parent is the predicate offense. I mean, it's absolutely stunning. And the court has affirmatively held that, it's an internal document, need not be given.
Also, I want to ask you one thing. The whole act of taking possession of properties under PMLA, do you think that also requires a relook? Do you see any review petitions being filed on account of what has happened with this judgment?
Absolutely. You see, it hits you in liberty, but it equally hits you on property. And this is usually forgotten. Today, you can attach a property even before registration of an ECIR.
Even before the registration?
Yes. On the ground that this is urgent, this is immediate, we will see later on. And in any case, you can always do it simultaneously. Like literally, you write an ECIR now and simultaneously you attach it. Okay. Secondly, you can take possession even before final confiscation. Possession is different from attachment. Attachment is a paper thing. Okay. Your property is frozen. But physically, it is still with me.
Okay, in possession, you take the property from
possession. The property is yours, of course. If it's your only house, you can allow the person to live. If there's a tenant, you can allow, but the possession is legally with them. Now, you have not confiscated. The procedure for holding that the property is a proceed of crime and deserves confiscation is a final procedure. But you have taken possession in the interim. And there are many properties which have either become dilapidated ruins or have become ED offices. There is a property in Bombay, very well-known public figure, whose property was attached, is now running as the ED office.
Is it so?
Yes, it's well known. And then there are issues of valuation. One of the problems is that, you attach a property, today's value is 1,000 rupees. You say, no, I will take the value which Tarun Nangia purchased it at.
But that's
apart from the fact that you purchased it 20 years ago, so therefore you only got 200 rupees as against 10,000 rupees today. Therefore, against the allegation of siphoning of 10,000 rupees, you attach only 200 rupee property. Therefore, you must attach 20 properties to Tarun Nangia.
so it can have a chilling effect. I mean,
Chilling effect. These are all things which the court could have plugged in terms of nitty-gritty safeguards without doing much violence.
I see. Only talking on jurisprudential basis, a number of eminent advocates, in fact, you argued before the bench. You raised so many points which we have earlier spoken in the earlier Saturdays with Singhvi shows. The judges appreciated the arguments and came out with this judgment, but also spoke that a larger bench could look at it. What really happened? You think that almost nothing by way of relief came in this judgment, despite arguments going on, I think, for well over a month.
See, I must immediately say that I personally have no complaint in the respect, the dignity with which they heard me, and the length of time they heard me. There's no problem on that. I am not complaining on that. I'm speaking for myself, and they were very polite and very nice and all the points were heard, understood, noted, and analyzed. And I think it was a pleasure to argue. I'm now talking of the result as a legal sense. I'm not talking personally about the bench. I'm talking about legal consequence. A major overshadowing issue was that the crux of the objectionable amendments are 2018 and 19. That again is being bandied around about prior ones, but the main ones are these. Now, both of them were bought as money bills. I also happened to be in Parliament then. A big was raised saying, look, what is the difference? If you bring it as a money bill, Parliament may have a debate, may have a discussion. It's irrelevant largely. Because whatever Rajya Sabha says or does, it doesn't matter for a money bill. It's a formality. The final word, it goes back. Suppose the Rajya Sabha was to completely reject the bill. Even then it can be passed because it's a money bill. So the argument raised in those petitions, one of them by my friend, Mr. Jairam Ramesh, where I'm also appearing, that look, mere certification by the Speaker, this is a money bill under Article 110, is not final and conclusive. It is subject to judicial review. Suppose you certify, and the second argument is that clearly PMLA is not a money bill. How can a completely a prosecutorial act, if that is so, then CRPC is a money bill, IPC is a money bill. Nobody normally speaks of IPC as a money bill. Money bill doesn't mean that a bill involves some money. Every bill involves some money. Therefore, this is, I think, a fundamental question. If this was right, if we are held right on this, in those petitions, then all the amendments of 2019 and 18 are bad. This, of course, was again, unfortunately, kept in a thanda basta. Because this is overriding. 70% of my argument just now on possession, on attachment, on whatever you asked me, came in by 18 and 19 amendments.
Yes.
Money bill point is right. Then the amendments are void, gone. So logically, again, this should be decided earlier. But unfortunately, this was kept away. So again, you had this cart before the horse syndrome has happened in 5-6 points of this case.
One of my last question to you would be, our three eminent judges, Justice A.M. Khanvilkar, Justice Dinesh Maheshwari, Justice C.T. Ravikumar, they delivered this judgment. And Justice Khanvilkar also said that a larger bench may, in the sense, look at this issue again. Do you think that this is certainly going to a larger bench and will be, in a sense, heard again?
No, Tarun, this matter is not going to a larger bench. The larger bench is the money bill point.
Yes. So this matter, unless a review petition is filed...
this is final and this is the end of the road as far as, of course, Supreme Court may reconsider the whole thing in some later issue. That's a different matter. But today, for all the 5 points I argued and the 4 or 5 points several other counsel argued, let's say total of 10 points, this is the final last word on PMLA. After all, it's the Supreme Court. After all, it's 3 learned judges. And therefore, the reconsideration will happen on the money bill issue.
Okay.
That is a
and if a review petition is filed in this, then this will be heard again. Is
of course,
that...
review and curative, of course, is a different procedure. Yes, that is open to all judgments. That is open to all.
Thank you for clearing the air on this judgment. A lot of people were curious, and I would request that we revisit this issue again, I think in a fortnight, because much would also happen by then. A review petition may or may not be filed. But of course, in public discourse, we see a lot happening. So it will provide us an opportunity to interview you again. But thank you so very much. It is, as usual, a pleasure talking to you. And for the first time, I noticed that you have a different background. And it looks good. So it's visual relief. Thank you.
So much. Very kind of you.
Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.